In this video, we will introduce proximate cause in negligence cases. And to understand proximate cause, we're going to look at it together with actual cause and see how actual and proximate cause together are necessary for causation. As in, what would this pedestrian have to show that the cyclist was the actual and proximate cause of any injury he received as a result of this accident? So we'll say Pete is crossing the street along a crosswalk with a walk sign, and suddenly Dudley comes by riding too fast on his bicycle, and now Peter is injured. If Pete wants to win a lawsuit against Dudley, he'll have to prove, among other things, that Dudley caused his injuries. And to prove causation, he'll need to prove first actual cause. And courts will usually ask, but for defendant's wrongful action, would there have been an injury? So we'll ask, but for Dudley's carelessness, would Pete have been injured? And to answer this question, we can create a timeline. First, Pete crossed the street with a walk sign. Defendant cycled too fast and did not stop at the crosswalk. And then there was an injury to Pete, which resulted from the collision. But if Dudley hadn't cycled too fast, and he'd remembered to stop at the crosswalk, Pete would have been just fine. So we can say, Dudley actually caused the injury because but for his actions, Pete would not have been hurt. So now let's look at proximate cause. So for actual cause, we asked whether, but for defendant's action, would the injury have occurred. However, for proximate cause, we need to know whether defendant's actions were sufficiently close in time or sufficiently close in space to the injury. Also, is this the type of injury we would expect to result from defendant's wrongful action? And here, yes, Dudley cycling too fast through the crosswalk and hitting Pete all happened in close proximity in time and space. And it is just the sort of injury we would expect from Dudley's carelessness when he rode too fast. So it seems fair to say that Dudley's actions were both the actual and proximate causes of Peter's injuries. But let's change the story, and we'll say Pete is crossing the crosswalk with a walk sign. Dudley rides through dangerously, but Pete jumps out of the way. And Peter is really happy because he's lucky to have not gotten hurt. And just as soon as he can, he calls his friend to tell her how lucky he was. But just as he is about to make the call, lightning strikes and hits the phone. The phone explodes and Pete is injured. So now, if Peter sues Dudley, can he prevail? Well, we can start with actual cause, and our facts are plaintiff crossed the street with a walk sign, defendant rode through the crosswalk without stopping, plaintiff was so happy defendant missed him that he decided to make a phone call, and then he was injured when lightning hit the phone. So in this case, if defendant had not rode through the crosswalk carelessly, plaintiff would not have felt the need to make that phone call. And so it seems likely if he had not taken out the phone, he never would have been struck by lightning. As a result, there seems to be a strong argument that Pete can prove that Dudley was the actual cause of his injury. But was Dudley's carelessness the proximate or legal cause? That seems to be unlikely. There was a whole series of events that led to Peter getting hurt, and a lightning strike to a phone is just not logically connected to a defendant riding carelessly with his bicycle. As a result, when it comes to proving causation, a court will likely reject Pete's case because Peter can't prove that Dudley's actions were the proximate cause of his injuries. To summarize, to prove liability, plaintiff must show that defendant's actions were both the actual and proximate cause of his injury. The defendant's wrongful action is the actual cause of an injury if, but for his actions, plaintiff would not have been hurt. Proximate cause requires a sufficiently close relationship between the defendant's wrongful action and plaintiff's injury.